After today's decision, the president can effectively exercise all those powers too. It may be true that after today, there's no more fourth branch of government, by which he means administrative state, but the fourth branch's powers still exist. They have just been reassigned to the president.
He's not wrong.
Yeah.
But I don't know. I want to unpack that a little bit because I need to convey to our listeners how thoroughly evil this Gorsuch concurrence is.
Welcome to Law and Chaos, where the Supreme Court is blowing up the government. Acting Attorney General Todd Blanche and his minions are inventing new ways to light themselves on fire in court, and E. Jean Carroll is kicking ass and taking names. We got a lot to cover, so let's get after it. Hey guys, I'm Liz Dye, and with me as always is Andrew Torres. Andrew, how are you?
I'm good, Liz. How are you?
I am all right. Did you have a nice weekend?
I did. Did you have a nice weekend?
I had a lovely weekend.
Oh,
I was spent some time with my child to celebrate their birthday, and it was lovely.
Oh, I'm really glad to hear that.
Okay, we have so much to talk about. Obviously, it was a Supreme Court decision day, and it was not a good one, and tomorrow is like to be worse. Tomorrow will be the last decision day of the October 2025 term, and we're expecting the birthright decision case, which will probably go fine, I guess.
Right, but it's not 100% on that and everything else.
Right, and there will be two decisions with respect to transgender rights and one regarding campaign finance. And I think it's going to be pretty bad.
I agree. I'm sad to say that.
Yeah. Okay, but we do have quite a lot to talk about today, and not all of it is gloom and doom. But first,
dun-dun.
Nugget alerts. Okay, first up, let's start with a big mazel tov for E. Jean Carroll. The Supreme Court denied the president's petition for cert in her original defamation verdict against him.
Yeah, I know we're going to spend most of the day talking about the Supreme Court's opinions again, but of course, the Supreme Court mostly does not take cases among litigants who would like to appear before it. So on decision days, what they do is put out an orders list at 9:30 a.m. before issuing their written opinions at 10.
And the orders list today said Trump v. Carroll, petition for certiorari denied. So the original verdict, the one where the jury said that Trump was liable for sexually assaulting Carroll and then defaming her, that verdict stands. It's done. Trump is tweeting some kind of thing about challenging it, whatever, done. And remember, there were two Carroll v. Trump trials, one for defamation that occurred before Trump left office and one for defamation that occurred after. Mm-hmm. And confusingly, Carroll, too, was tried first because Trump spent 2 years making various presidential immunity arguments that delayed Carroll won.
Yeah.
In Carroll 2, the jury returned a $5 million verdict. And in Carroll 1, the second trial, the verdict was $83 million. And that was because Trump had, in the meantime, continued to defame Carroll so viciously. And the jury needed to make a penalty large enough to deter him from continuing to do it.
That verdict is still on appeal. And that one could potentially be undone by the Supreme Court's howler monkeys, who might decide that Trump really was acting within his official duties when he attacked E. Jean Carroll, that he was just commenting on the news of the day or some such. They have so far taken a very maximalist stance on presidential immunity.
But no matter what happens, the important thing here is that the first verdict stands. Trump has been adjudicated as a sexual abuser who assaults women, and he will finally have to pay E. Jean Carroll what he owes her.
Amen. And speaking of defamation, you know who isn't getting paid?
Would that be your old professor, Alan Dershowitz?
Indeed it is. So Dersh has been suing CNN for 6 years now, or trying to anyway, over comments that he made during the first Trump impeachment. Dersh made this long, convoluted argument about how presidents always think they're doing the best thing for the country. And so when a president, say, tries to extort the leader of a foreign country to do us a favor, though, and announce a sham criminal investigation into his political rival, maybe that's presidential duty. Honestly, Dersh said like 10 stupid things in a row, but then CNN only played part of the clip. I mean, it was a pretty lengthy part, but whatever. And Dersh filed this goofball lawsuit saying that it was defamation by implication because CNN didn't play the entire dumb 7-minute long thing that he said, which you live on media, like you know better.
Right. So that lawsuit was originally tossed by the trial judge, Raj Singhal, Trump appointee, who made sympathetic noises, but he said his hands were tied by New York Times v. Sullivan. Remember, Sullivan is a Supreme Court case that set out the actual malice standard for public officials, which means that the plaintiff has to prove that the defendant knew that the statement was false or was reckless about confirming the veracity of it. And Dersh has been trying to use his case as a vehicle to overturn New York Times v. Sullivan.
To minimal effect. But look, the project to overturn New York Times v. Sullivan is a pet project on the far right. I think strategically that's kind of insane. I mean, Fox News would go bankrupt in a year if public figures could sue it for defamation on the regular standard. Outlets like One America would be gone in a day, right? Donald Trump would have to worry about a lot more than E. Jean Carroll. But apparently that is a trade they have decided they are willing to make because plenty of conservatives do want to get rid of New York Times v. Sullivan. In this case, the 11th Circuit that sits over Florida said, nope, not touching that one.
Yeah.
And they affirmed the trial court on the theory that CNN actually believed that they had properly characterized Alan Dershowitz's ramblings, so he would have lost on the lower standard for non-public figures anyway. And then this morning, the Supreme Court also said, pass, no thank you. But Justices Thomas and Gorsuch would like to weigh in to remind us all once again that they think Sullivan is made up, unlike the rest of what they're doing here, which is just calling balls and strike.
Ha ha, f*** you.
Also, from the orders list, the court will not consider an order of qualified immunity for prison guards who pepper sprayed a prisoner with asthma because he was on a hunger strike and refused to come out of his cell, and then they locked him naked in a room that was 40 degrees for 23 hours.
F*** you, not ha ha.
Yeah. Okay. In less horrifying news, the District of Columbia has agreed to pay Sam O'Hara $50,000 to settle his lawsuit against the Metro Police. You might remember when Donald Trump deployed National Guard units to Washington, D.C., O'Hara was the guy who walked behind the Ohio National Guard unit, filming himself playing the Imperial Death March from Star Wars. Which, good job. And a very special snowflake from that Ohio unit named Sergeant Devin Beck called 911. Presumably he was in fear for his life. The D.C. cops, responding to that 911 call, restrained and handcuffed O'Hara before releasing him because the First Amendment is still a thing in this country. O'Hara has settled his lawsuit against the Metro Police. He has not settled his lawsuit against Sergeant Beck, although I'm very certain that he would like to, which is a pretty good demonstration of how different the law is when your civil rights are violated by a state actor, and you can bring a claim under the statute, 42 U.S.C. Section 1983, as opposed to when they're violated by a federal actor where you're stuck with this implied right of action.
Sadly, we do not have time today for an Andrew Torres deep dive into the slow death of Bivens v. 6 unknown federal agents.
I will not fight you, Father.
And speaking of villains, John Yoo is back in the news.
I see what you did there. Yoo is a lawyer who worked in the Office of Legal Counsel in his 20s under President George W. Bush. He is most famously known as the author of the torture memos that said the, quote, enhanced interrogation techniques used on prisoners at Guantanamo Bay and elsewhere after September 11th were totally legal. Those memos have since been withdrawn, but Yoo went on to a lucrative career as a right-wing commentator, as well as inexplicably a professor at UC Berkeley Law School for the past 30 years.
And he's continuing his career of laundering the most insanely illegal shit into polite discourse by joining this ludicrous investigation in Florida. It's the one where Todd Blanche is trying to string together everything from the 2016 election through the Jack Smith indictments, including the Russia investigation, into one giant conspiracy so he can lock up Hillary Clinton and Barack Obama and Jim Comey and Jack Smith and everyone else who ever wronged Donald Trump.
Right. The point of this exercise is to defeat the statute of limitations on 2016 claims by saying that each one of these events, stretching back over a decade, were all part of one big conspiracy, which is still ongoing. It is, to use the legal term, beyond stupid, which is why they parked it in front of Judge Eileen Cannon in Fort Pierce and not in a real court near where these supposedly criminal activities took place.
And they recently put Joe diGenova in charge of this investigation.
We're going to need your special expertise on this one.
So Joe diGenova is this Fox News figure who he hasn't been a prosecutor since the 90s. I think he's like 81. He was, however, deeply involved in these supposed conspiracies and investigating, since he worked with Rudy Giuliani to spin up the Ukraine conspiracy against Joe Biden. Anyway, now Yu has been sworn in as a special advisor to this Tinker Toy investigation in Fort Pierce. Yu told Politico, quote, "I'm just signing on as a consultant on any kind of constitutional law issues they may encounter. I've known Joe and his wife Vicky Tensing for more than 3 decades, and if they in the United States of America think I can help him in any way, my answer is yes."
I mean, his answer was also yes when his pal John Eastman called upon him to testify as a character witness at his disbarment proceeding. And Eastman lost his license to practice law. So, have at it, John. But still, like, this is some deeply embarrassing shit for our profession.
Yeah. And also John Yu pretending that he is unaware that his actual job in this life is to be a laundry and to kind of legitimize ridiculous legal theories and say, like, no, that's actually sensible. He's like Jonathan Turley. Like, I mean, it's a good grift. Congratulations. But to say I'm only doing this because I am a person of the strongest integrity who wants to help my government it's a little much.
Yeah.
Okay, and before we go to break, let's briefly flog the written post on the internecine battle inside the National Rifle Association, better known as the NRA. The gun group had this very public implosion in 2019 when it was publicly revealed just how much corrupt self-dealing was going on under the leadership of its longtime president, Wayne LaPierre. Basically, they had this advertising company called Ackerman McQueen that would bill the NRA for media or whatever, and then pay out of ACMAC for stuff that the nonprofit wanted to keep off its books, like clothes and vacations for LaPierre and his family, or a television contract. Like they had Ollie North come in and be the president of the agency, which meant he had to quit his gig at Fox News, because of course it was Fox News. He had to quit his gig as a commentator on Fox News, and they said, no, it's fine. We'll replace your salary. You can just present on NRA TV, and we'll give you $1 million a year. So it was insane self-dealing. And they were even going to buy a mansion for Wayne LaPierre in Dallas through ACMAC. It was like $3 million. There was going to be just like a whole lot of media that year. Anyway, that did not happen. And then New York Attorney General Letitia James more or less dismantled the NRA. And then D.C. Attorney General Carl Racine sued the NRA Foundation and forced it to make major changes to its governance model.
Yeah. And to understand this story, you really have to appreciate the difference between a 501c3 and a 501c4. Those are subsequent sections of the Internal Revenue Code that govern tax-exempt agencies. The 501c3 is a charitable organization that does not lobby for political causes, and donations to it are tax-deductible. A 501c4 is a nonprofit that does lobby, and so donations to it are not tax-deductible. The NRA is currently a 501c4, and the NRA Foundation is a 501c3. So those organizations are currently suing each other because the NRA says that the foundation has stolen its name and breached various laws governing charities. And the foundation, for its part, says that the NRA is illegally trying to co-opt its assets to prop up its disastrous balance sheet. That they're all just jackals at this point, fighting over scraps.
Yeah, sadly, I think a lot of this is like a dog that caught the car situation.
Oh,
right?
Say more.
I mean, look. Thanks to the Supreme Court, we're clearly never getting gun control, right? And the entire purpose of the organization, or at least in the past 25 years, during the LaPierre era, has been to bilk the rubes, basically, by telling them that Obama is coming for them and their guns, and so they need to, arm up and oppose any kind of gun regulation at all. And, clearly nobody's coming for their guns, and
right.
if they did, the Supreme Court would fight them off. And now that the organization itself has been revealed to be so corrupt, I don't think that there is a strong culture war or political reason for this organization, the NRA, to exist. It used to be so powerful, and now it's not.
That's really interesting. I have thoughts on creationist organizations in the same way. Well, I'll spare them for a special.
I will not fight you, Father.
But I do want to contrast what's going on with the NRA with the absolutely bullshit indictment of the Southern Poverty Law Center.
Yeah,
right? The Department of Justice's theory, remember, is that the SPLC needed to invent some racism to justify its continued existence, and so it paid informants, which indirectly funded the hate groups that it was pretending to dismantle. We've discussed all the reasons that that's horseshit. But here you have the National Rifle Association, this conservative charity, engaged in decades of the most scandalous self-dealing, and the feds could not care less. You don't need the counterexample to persuade you that this Department of Justice is totally corrupt, but the comparison's really hard to ignore.
Totally agree. Okay, we're going to take a quick ad break, and then we'll be back to discuss Katie Phang's lawsuit against the Justice Department, which she appears to have won. Unless you are a subscriber at lawandchaospod.com or patreon.com/lawandchaospod, in which case you'll be getting right to it. Okay, let's talk about Katie Phang. She is a lawyer and a journalist in our space. She's a former MSNBC or maybe MS Now commentator. And like us, she has filed lawsuits trying to shake loose certain information that the Trump administration is withholding. Specifically, she sued to force the DOJ to disclose portions of the Epstein files, which they were legally obligated to kick loose, but haven't done, particularly names of co-conspirators, as well as details about allegations against Trump himself.
Right. Remember, Trump tried desperately to block the release of the Epstein files, but then a handful of Republicans joined with Democrats and, via discharge petition, forced a vote on the Epstein Files Transparency Act, at which point almost all the Republicans decided they too were actually in favor of it, and then the law passed. That law specifically said that the names of co-conspirators could not be redacted. The only permissible redactions were CSAM, child sexual abuse materials, depictions of injury, death, or physical abuse, national security or foreign policy information, or materials that would jeopardize an active federal investigation or prosecution. And Todd Blanche has already said that there aren't going to be any more prosecutions, so that last one is a dead letter.
Yeah, I cannot stress enough how much this story is about Todd Blanche being a jackass who cannot help but run his mouth.
Yeah, it was similar to the Kilmar Abrego Garcia case, right? Like that case blew up because Blanche made it so clear that it was a vindictive prosecution.
Exactly. So Phang's theory of standing here is that she's a journalist who reports on the law, and the failure to disclose these Epstein documents blocks her from doing her job. So she moved for a preliminary injunction asking Judge Emmett Sullivan to order the DOJ to submit a privilege log as required by the statute, the EFTA. Mm-hmm. And she wants them to disclose the names of the co-conspirators along with some other stuff like documents in foreign languages, which has been withheld or something. In response, the DOJ says that where an adequate remedy at law exists, the Administrative Procedure Act's waiver of sovereign immunity does not apply, and the Freedom of Information Act, FOIA, provides exactly that remedy here. The Epstein Files Transparency Act is, in essence, a disclosure statute. Read in pari materia, the Epstein Act supplements FOIA. It does not create a freestanding jurisdictional hook outside of FOIA's remedial framework.
Oh, okay. In pari materia means on the same subject or relating to the same matter. Blanche is trying to argue that the Epstein Files Transparency Act is just a normal statute, right? Not what it is, which is an extraordinary bill that mandates broad-based disclosure with only that handful of tiny, narrow exceptions. And Blanche's argument is, well, there's no enforcement mechanism built into the Epstein Files Transparency Act. So, you should just treat this, go get in line with the rest of the FOIA requesters, and we will see you never.
Which would have worked fine, or maybe it wouldn't have. But the DOJ was, at that very moment, responding to FOIA requesters about the Epstein files with a big middle finger. And they said, essentially, everything subject to FOIA has already been released, so you get nothing. Which kind of undercuts the claim that Phang should have had to ask for this stuff via FOIA.
At which point, Judge Sullivan instantly grants the requested injunction, orders the Department of Justice to produce the documents by July 2nd, and denies the request for a stay since the government has no interest in continuing to break a law it was supposed to have complied with 6 months ago.
Right. At which point, Enter Stanley Woodward. He's the associate AG. He's a former Trump lawyer, and he's a guy who clearly fancies himself to be the true heir to Roy Cohn. We talked about him a lot on this show. Woodward,
not Cohn.
Well, true. So Woodward, but when Woodward enters his appearance in a case, it's a sign that one, some absolutely crazy shit is about to go down, and two, no one else at DOJ wants to touch said crazy shit with a 10-foot pole.
Yeah. And here, the crazy shit is the government is definitely going to move for emergency relief from the D.C. Circuit. But speaking of Woodward, before we talk about the Supreme Court cases, you want to give us a little update on the slush fund case? Because that definitely proves your point about him being a chaos monkey, and not in a good way.
Not like you guys. You guys are the good kind of chaos monkeys.
Yes.
Okay. So the January 6th weaponization slush fund case is before Judge Leonie Brinkema in the Eastern District of Virginia. That's the challenge to this supposed settlement of Trump's lawsuit against the IRS, where he erected this $1.776 billion slush fund to give to his pals. Judge Brinkema said a couple of weeks ago, look, you guys, the government, say this boondoggle is dead, but you're not saying it to me under oath. So what I need is for you to have Acting Attorney General Todd Blanche, Associate Attorney General, the aforementioned Stan Woodward, and Treasury Secretary Scott Bessent file sworn declarations saying to me that this thing is really dead and not coming back. If you do that by Friday, January 24th, I will dismiss this case and we can all go on about our business.
You may surmise that the government did not, in fact, file said declarations.
Yeah, I was pretty sure they would file something, but I figured what they filed would be worded very, very carefully so that they could thread their way through and give them enough wiggle room to resuscitate this fund if they ever wanted to.
Liz, have you ever met Stan Woodward?
I mean, not personally, but I am familiar with his oeuvre.
Yeah. We were actually involved in a case more than a decade ago. He was not as obviously wacko back then. Anyway, on Friday, Woodward filed something captioned as a notice. It was a notice of, how very dare you?
Yeah, that's an interesting way to address a federal judge.
As a practitioner, I would not recommend it. So Woodward said, such declarations are unnecessary, and the compelled testimony of senior officials from the executive branch implicates serious separation of powers concerns.
Okay, Stan, keep your panties on. First of all, no one is talking about deposing cabinet officials or putting them on the witness stand. And two, nobody's compelling anything, right? The judge said, if you want out, say under oath what you've been saying publicly.
Yeah, Woodward made some convoluted argument that was basically, why don't you accord me the presumption of regularity? It literally was, well, if Todd Blanche says it publicly, there won't be a fund, and I'm saying it here to you in court as a lawyer, how dare you suggest that we're lying? I mean, there was more to it than that, but not much more. I mean, but basically, this is a demand that his Department of Justice be treated like every prior Department of Justice. And the reason not to treat that is because this Department of Justice is floridly corrupt.
Right. So Judge Brinkema said, fine, suit yourself. I wasn't compelling any testimony, but, you might wind up having to testify if you insist on continuing this case. And she said, fine, and she set a briefing schedule.
Great job, Stan. No notes.
Yeah. Okay, it is time for our doofus of the day.
I love this thing.
You doofus! Historically, Obamacare had 9 million people on it. 9 million people. This year, over 23 million people apparently signed up. But of the people who signed up, 40% never used the insurance. Let me ask you a question, John. You have health insurance. Do you use it once a year? Buy a prescription, you go visit a doctor, call somebody?
If I don't use it once a day, it's pretty infrequent.
Well, in Obamacare right now, 40% of the people ostensibly signed up never used the insurance. So it raises, again, the reality that there are many people who are signed up who are getting paid for but don't believe they have the insurance, don't know they have insurance, didn't want the insurance. And these brokers are able to make a ton of money off the American taxpayer. So, of course, the Democrats are arguing aggressively that any people who leave Obamacare is only happening because of the enhanced premium subsidies that were put in place for a short period of time during COVID by the Democrats. That's not right. The reality is we have a lot of fake people on the policies. We want them off because they don't want the insurance. They're covered elsewhere, or at least they never wanted to be in this program. If they want other ones, it's fine. And we're going to get to the bottom of this. And what Secretary Kennedy announced on this video is really critical. Yeah. 1 million people with fake Social Security numbers, that's an insult to the American people. We're not going to tolerate it.
All right. So that was Dr. Mehmet Oz, the administrator of the Centers for Medicare and Medicaid, explaining that there's something fishy going on with that Obamacare.
Do you remember he was locked in a Senate race with John Fetterman? Like, wow.
Yeah, wow. Those crazy times. But I believe his argument here is that it's fine if millions and millions of people lose their health insurance because Obamacare premiums go up, because actually those people didn't really want the health insurance in the first place. They were just enrolled by tricky brokers, and they actually have other insurance.
They're getting paid by Obamacare. I would like to sign up for that health insurance.
I would like that health insurance that pays me. That would be better than what I have. I mean, what I have is stunningly expensive, and it's not the Obamacare because the premiums are gone. So don't love any of that. But Dr. Oz, you have definitely earned the Law and Chaos Doofus of the Day. Okay, let's do this. Let's talk about the Supreme Court's opinions from today. We will start off easy with a 5-4 decision that went the right way, with Roberts and Barrett joining the court's 3 liberals. This is the case about late arriving mail-in ballots that were postmarked by Election Day. Actually, I predicted on camera that this would go the other way, and now I have to eat crow. All right, it is what it is. I'm glad to be wrong, right?
Yeah.
So the Republicans' argument here is that accepting ballots after Election Day is illegal, despite the fact that about 30 states do it and have done it for years. The dissent was penned by Alito, and it's full of nonsense frothing about election fraud.
Yeah, it is such a tell that they will do literally anything to restrict access to the ballot because Republicans know that a high turnout election disfavors them. I mean, just think about this, right? This is a rule of general applicability. This involves what happens when somebody in good faith mails their ballot on time before Election Day, but because of the vagaries of the post office, it arrives soon after Election Day. Like that should affect Republicans as much as Democrats, right? I mean, if the post office is going to lose X percentage of votes and deliver them late, like statistically speaking, that haircut is going to affect each party in the same proportion to the general turnout. Like this is not like absentee ballots versus in-person in 2020 during COVID, where voting in person became a whole culture war issue.
I mean, okay, yes, and think about that long shot race you and I were watching last week, right? In Baltimore, they count early votes immediately, like the second the polls close, and you and I knew that one candidate had won because the other was, I mean, look, I'll just be straight with you. This candidate's main constituency was Orthodox Jewish voters, and that is a demographic cohort that we knew was going to be more likely to vote early than the general population. I knew it because when I was younger and more religious, I planned my time very differently. My week was shaped very differently. And that's outside the scope of this podcast. But you and I and my guy Joe Dye knew the minute the polls closed that this candidate was going to lose because she was already behind in early voting, which was her most favorable constituency, which is a good thing because I have had enough of being represented by this person who is under federal indictment. Anyway, I read this argument about late arriving ballots as a point-shaving mechanism for Republicans because they anticipate that their voters will vote early or in person, not slide a ballot into the mailbox on Election Day. And yes, in a world where there was an even distribution of ballots across all methods, it wouldn't matter what the rule was as long as it was evenly applied. But we do not live in that world, and that's why they're not going after early voting, which is also, let's be clear, a vote cast outside of Election Day.
That is a really good point. Okay, so let's talk about the opinion, which was written by Justice Barrett. The case was brought by the Republican National Committee challenging Mississippi's law requiring officials to count absentee ballots postmarked by Election Day and received up to 5 business days later. The Constitution says that states run elections except when Congress speaks. And Congress has indeed spoken 3 times about the timing of elections. In 1845, it fixed a uniform day for presidential elections, which is the Tuesday after the first Monday in November, because before that, states held elections on different days. Voters could travel and vote in multiple states. And the whole thing was a mess, right? In 1872, Congress said that elections for the House of Representatives should be on that same Tuesday. And then in 1914, they did the same for senators. That's it on timing of elections. And critically, none of those laws say anything about when ballots have to be received.
Yeah, the argument here is basically whether casting your ballot takes place when you send that ballot out into the world or when that ballot is received. And the record is clear here that the reality in America was never that all the ballots were there and got tallied on Tuesday by midnight and we knew the winner before we went to bed, or at least we knew it when we woke up on Wednesday morning. I mean, that is what Republicans want you to believe is normal. And if we just massively restrict access to the ballot, we'll make elections great again. And we can go back to that, halcyon Eden.
And yet, Republicans rail against machine tabulation of ballots, which is the only thing that allows us to know results inside of a week.
Or a month.
Yeah.
I mean, when they did their hand count in Maricopa County in Arizona, it took 6 months.
Right.
Okay. But let's be clear. The Eden of this, all getting counted by midnight, it never existed. It didn't exist in the early American era when people were like riding around on horseback to transmit information written on actual pieces of paper. It didn't exist during the various wars where we had large numbers of people, mostly young men, far away from their home states on Election Day. And it didn't exist in the modern era where each precinct has a distinct ballot with like a dozen races on it. And counting these, ballots takes a long time. That's why we don't do that whole electoral college certification until January, because people anticipated, the framers anticipated that it was going to take until December 14th to finish counting.
Yeah, Barrett talks a fair bit about UOCAVA, that is the Uniformed and Overseas Citizens Absentee Voting Act, as really the perfect illustration of why these arguments about the sacred inviolability of Election Day are ahistorical, as you point out, Liz, and wrong as a matter of law, right? So UOCAVA requires states to let military and overseas voters cast absentee ballots in federal elections. And that statute very clearly assumes that the deadline for ballot receipt is up to the states themselves to decide. It does not say this UOCAVA ballot must be received by the local registrar by the first Tuesday after the first Monday in November or whatever, right? Instead, what it says is the ballot must be received not later than the date by which an absentee ballot must be received in order to be counted in the election, right? That is a referral back to the state law. And it says that UOCAVA ballots have to be sent to the voter, quote, at least 60 days before the deadline for receipt of the state ballot under state law. So Congress clearly knows that states set their own deadlines, and that's fine with Congress, and Congress is the body responsible for saying when elections are held.
Unless it's the state.
Right. It is, unless Congress explicitly and specifically overrides what the states have said, and they haven't done that.
Right. And Alito's response to that is basically to argue that during the Civil War, states required ballots to arrive by Election Day. Ipso facto, they must have known that they could not accept ballots after that, because otherwise the states would have extended the receipt deadline if they thought they were allowed to.
Can we also have the other Civil War era? Like, let's not count from 13 states? I mean, that is weak sauce.
Yeah, right. So Barrett's answer is essentially, you can't prove that, which is correct. States had plenty of independent reasons to require Election Day receipt. She talks about them wanting ballots to be open publicly in front of neighbors. That it was kind of a community, it was a community policy to count in that way. They wanted officials assembled for in-person voting to process all of the ballots at once. And maybe it didn't occur to them that they could extend it. No one knows why, but you can't say, well, they didn't do it, so that must have been the law.
Right.
And she makes a good point that Alito's own theory, if you followed it to its logical conclusion, would also call into question the legality of early voting and adjudicating provisional ballots, right? Not to mention allowing people who mess up their ballots to come in and cure them.
Yeah. Alito's arguments were sloppy and mendacious even for him, although Roberts really outdid him on that score in the Slaughter case, which we're going to talk about in a minute. But here, Alito says, allowing absentee ballots to pour in over the days and weeks after Election Day, by which point preliminary election returns are being publicly reported, creates greater opportunity for fraud and risks further undermining the public's confidence in election integrity.
How does this create a greater opportunity for fraud? What is it about the late votes, which were all, of course, postmarked by Election Day and delivered by the mailman and sealed? How could they be more likely to be fraudulent than a mail ballot that arrives a week early?
Look, non-existent fraud is not the Supreme Court's job to police in any event, right? Alito does not say. Right? He does not give any explanation beyond that, sort of right-wing talking point. He does go on to say, it is undeniable that a prohibition on counting late arriving ballots would provide an additional hurdle for bad actors seeking to stuff ballot boxes when early election results suggest a tight race. The majority incorrectly removes this safeguard from federal law.
I'm denying it. I'm denying. How do you stuff a ballot box after Election Day?
Dinesh D'Souza can tell you.
Right. This safeguard that he refers to was never in the law. They can't be removed from the law. That's why, states have been accepting late ballots for decades. I think that we need a constitutional amendment so that no Supreme Court justice can watch Fox News because obviously their brains are cooked from all of this complete horseshit that they've been, mainlining about rampant election fraud. And then they bootstrap onto these lies about rampant election fraud to say, well, we have to change the law or, impose these restrictions so that people won't believe that there's election fraud.
Right. When he says further undermining the public's confidence in the integrity of election, it's the court's jobs to say the election is secure.
Right. It's like that goose meme, who undermined faith in the elections? Who undermined faith in the elections, motherfucker? All right, we're going to take a quick ad break, and then we will come back and talk about Cook v. Slaughter.
And we're back. Okay, Liz, let's talk about Trump v. Slaughter and Trump v. Cook. Those were the cases in which Donald Trump illegally fired or tried to fire members of executive branch agencies. Today, the Supreme Court blessed that practice in a 6-3 decision that says categorically that the president has the power to fire any head or member of the governing body of any executive branch agency for any reason or no reason whatsoever, with no exceptions. And then, on the same day, Chief Justice Roberts authored an opinion that creates an exception. We will get into that. Look, we knew that these cases were coming. It doesn't make it sting any less.
Yeah. So let's start with Slaughter. In 1914, Congress created the Federal Trade Commission, the FTC, to prevent unfair methods of competition in commerce. The FTC Act says that it will be governed by 5 commissioners appointed by the president and confirmed by the Senate. No more than 3 commissioners at a time can be from the same political party. Commissioners serve staggered 7-year terms so that they cross multiple presidential administrations, and they can be removed by the president from office only for inefficiency, neglect of duty, or malfeasance in office.
When Trump's second term began, Biden's FTC chair, Lina Khan, resigned, as is customary. That left 2 Democrats and 2 Republicans on the FTC. And all Trump had to do to gain control of this agency was nominate some dingus to be chair, let the supine Senate rubber stamp that person, and then Trump would control the FTC. But Trump didn't want to control the FTC. He wanted to destroy it. So in March of 2025, he just fired the 2 Democratic commissioners, Rebecca Slaughter and Alvaro Bedoya. Trump did not pretend to do so for cause under the terms of the FTC statute that you just read, 15 U.S.C. 41. Trump just said that their continued service was, quote, inconsistent with his administration's priorities and claimed the right to fire them pursuant to his inherent authority under Article 2 of the Constitution.
Rebecca Slaughter sued, and the district court ruled in her favor on the merits and ordered her to be reinstated. The D.C. Circuit refused to stay that injunction because of this 1935 case called Humphrey's Executor versus United States. That case involved an FTC commissioner named William Humphrey, whom FDR wanted to fire without cause. And the Supreme Court unanimously said that Congress had the power to protect certain executive branch officials by making them fireable only for cause.
Now, we are back with the exact same question about the exact same agency, the FTC, but this time the Supreme Court reached the opposite answer. And as we said, we knew Humphrey's executor was headed for the chopping block. We got that. That was made very clear to us when this Supreme Court stepped in on the shadow docket, stayed the district court's order, and granted certiorari before judgment, which meant that they took the case on the merits directly from the trial court and bypassed the D.C. Circuit entirely. As soon as that stay was entered by the Supreme Court, Trump's firings went into overdrive, right? He has just burned down the federal bureaucracy with no plan to rebuild it. I mean, Trump has not even bothered to try and confirm his own FTC chair. The commission today has just those two remaining Republicans on it. They are sitting around doing nothing, apparently, because the FTC lacks a quorum to even convene to do business.
Yeah. And today, the Supreme Court formally overruled Humphrey's executor, holding that under Article 2 of the Constitution, Donald Trump can just fire the Democrats who lead these executive agencies or these boards for no reason whatsoever. And the point of these laws was to ensure that there would be nonpartisan continuity across administrations, that there wouldn't be just leadership in every agency beholden to the partisan will of the president. And that was a deliberate decision so that we would have good government expertise. And the Supreme Court said, screw that. And that's why this decision is such a disaster. And a landmark decision in its own rights, right? It's a disaster for the government, and it's a disaster because it is such a big middle finger to all of the things that the Supreme Court purported to care about, right? Continuity across its own ruling, stare decisis, right? And it's just a big, dunking stare decisis, the principle of continuity of decisions in the trash can.
Yeah. Obviously, you and I have talked a lot about this court's jettisoning of stare decisis. I really like the way Justice Sotomayor put it in her dissent in this case. She says, seldom, if ever, has this court worked such a profound bait and switch on a co-equal branch of government. For more than 90 years, Congress believed, with this court's express approval, that it was allowed to create a workable government, including by granting certain agencies tasked with certain responsibilities some independence from presidential control. In rejecting that project, after decades of promising the political branches that structures like the Federal Trade Commission were permissible, this court creates an executive branch that Congress never dreamed of establishing and now has little hope of ever reining in. And I think I'm going to start using that formulation for disregarding stare decisis, which, sounds Latin-y and like it's a breaking a promise. That's what this Supreme Court is doing. Okay. I also want to talk about the internal legal logic, or lack thereof. Chief Justice Roberts says that Article 2 vests the entirety of executive power in the president alone, and therefore, for the president to be democratically accountable to the people, he has to have absolute control over the people working under him. If he can't fire them, then the voters won't know who to hold responsible for what the government does.
Well, that's ridiculous. It's also not what the Constitution says.
Yeah,
right? The Constitution is completely silent about the president's power to remove officials. And the Appointments Clause does not give the president absolute control of his underlings, right? We've talked so many times on this show about the president having to get his U.S. attorneys confirmed. Article 2, Section 2, Clause 2 says the president shall nominate and by and with the advice and consent of the Senate shall appoint all other officers of the United States, right? If he can't appoint people without the Congress's buy-in, why can he fire people without Congress's buy-in?
Even more than that, right? Because while it is correct that the Constitution is silent about the power to fire, the framers did have thoughts about the power to fire. In fact, here's how Alexander Hamilton put it in Federalist Papers number 77. He said, It has been mentioned as one of the advantages to be expected from the cooperation of the Senate in the business of appointments that it would contribute to the stability of the administration. The consent of that body, meaning the Senate, would be necessary to displace as well as to appoint, right? So the reason why the Constitution doesn't mention firing is because this was the understanding. The fact that you needed Senate confirmation to confirm an appointee meant that you needed the Senate's confirmation to remove an appointee. Hamilton also adds, a change of the chief magistrate, therefore, would not occasion so violent or so general a revolution in the officers of the government as might be expected if he were the sole disposer of offices. Where a man in any station had given satisfactory evidence of his fitness for it, a new president would be restrained from attempting a change in favor of a person more agreeable to him by the apprehension that the discountenance of the Senate might frustrate the attempt and bring some degree of discredit upon himself. This is the exact same question that we have today. And here's Alexander Hamilton saying, no, of course the Constitution is not going to let the president just fire anyone in the executive branch at will. That's madness.
Yeah. So, okay, let's talk about the implications of this decision, which are really staggering. Pretty much every major governmental agency that was created in the past 100 years has been modeled after the FTC. And now every single one of the protections that Congress built in to keep those agencies from falling under the sway of a totally politicized president.
Hypothetical.
Right. It is gone. Right. And let's be clear here. What Trump is able to do now, he cannot get people confirmed to lead those agencies without the Senate. All that he wants is to wreck them so that they don't have quorums so that they can function. Basically, he doesn't want things like the Consumer Financial Protection Bureau or the Merit Systems Protection Board or the Federal Trade Commission, because those are the agencies which police bad conduct by people with money. And that's why he wants to burn those things down. He has no plan to reconstruct them. All he wants is to ensure that they cannot function. And that is a thing he can do by firing them. He cannot, he can put in acting people. He can't put in acting board members. He could, in some of these other official capacities, right? He's fired U.S. attorneys, but he can't get new U.S. attorneys in there. He can sort of play this game with acting officials or whatever. But with these agencies like the FTC, he can't get anybody in there. The only thing he can do is ensure that the agency ceases to function for the rest of his presidency.
I'll tell you another area that I think could be the next battlefield in this, and that is using the threat of terminations as a club to make these independent agencies do what he wants. And adjacent to independent agencies are Article I courts, right? Because immigration judges, administrative law judges, they too are appointed by the president with the advice and consent of the Senate. And so now I think, following the logic of this decision, that Trump can fire every ad law judge, every immigration judge in the country. Yes, the opinion explicitly reserves on that question, so there will be litigation, but this was 6-3, right? I don't expect that litigation is going to save those jobs. And so if all of a sudden the instruction comes down to immigration law judges, you better not start ruling in a particular way or you're going to find yourself out on the street. I don't know that they're going to have much success challenging their termination.
Yeah. And look, the unitary executive theory is absolutely a power grab on behalf of the presidency, right? But it's also a power grab by the courts, by this court and this court alone, now that they have the majority. We've talked about this a bunch of times, that what is different now is that this Supreme Court, with its 6-3 majority, has decided that it will remake American society and American laws in its preferred image. And Justice Neil Gorsuch was real candid about that today. Here's what he said in his concurrence. Today, independent agencies do not just exercise executive law enforcement powers. Congress has also delegated to them vast legislative and judicial powers, effectively allowing those agencies to make laws and decide disputes under them. And after today's decision, the president can effectively exercise all those powers too. It may be true that after today, there's no more fourth branch of government, by which he means administrative state, but the fourth branch's powers still exist. They have just been reassigned to the president.
he's not wrong.
Yeah.
But I don't know. I want to unpack that a little bit because I need to convey to our listeners how thoroughly evil this Gorsuch concurrence is, right? Because it's hidden behind his usual mix of dull pedantry, lying about history, and self-adoration. But here's what he says. Gorsuch says, open-ended delegations of legislative power have not gone away. Now they will just be exercised by agency officials who answer to the president. The power to write new regulatory crimes still exists, but now the pen ultimately rests in the president's hand. The ability to judge disputes in-house remains, but now the House is white. Good turn of phrase. The whole of the president's authority also may be greater than the sum of its parts. It would be one thing if today's decision afforded the White House more control over the airwaves, or financial markets, or energy, but presidents will now enjoy waxing authority over all of those areas and more. A business out of favor with the party in control of the White House might be able to stave off an FCC investigation, but can it survive a subsequent FTC rule declaring unlawful one of its long-standing trade practices? What about an in-house adjudication by OSHA, or a prosecution for a new crime the SEC announces? Not to mention what these now coordinated powers could do to disfavored individuals who lack the resources needed to fend off such attacks. And let me remind you, this is a concurrence.
Yeah.
This is saying, I voted for this thing. So look between the lines. What Gorsuch is saying is, okay, sure, we just blew up independent agencies. We endorsed a unitary executive because we know that giving that power to Trump is going to serve our business and our political interests. But one day soon, there's going to be a Democratic president, and we're going to need to change those rules back again. And who's going to be there to rein in this hypothetical, out-of-control Democratic unitary executive that we just created? Why? This Supreme Court, of course. I mean, that is your point, Liz, right? Here's how Gorsuch ends that concurrence. He says, now we face only two ways forward. Let presidents exercise all those powers or begin subjecting them to the Constitution's constraints. We have no shortage of tools. The only real question is whether we will use them. Doesn't that just give the game away?
Yeah. Okay. So let's talk briefly about the exception case, which is Trump v. Cook. That one came out of Donald Trump's efforts to fire Lisa Cook from the Federal Reserve Board of Governors before her term expires in 2038. Like Slaughter, the law protecting the Federal Reserve says that she could only be fired for cause. But unlike Slaughter, Trump did not challenge the constitutionality of that law. Instead, he had his crony Bill Pulte, the housing czar and now currently acting DNI, slime her with this fake bullshit about mortgage fraud. And then he said, well, now I'm firing her for cause. The district court enjoined that firing. But this time the Supreme Court declined to block that. So the court's injunction on the firings remained in effect, and Lisa Cook is still on the Fed today. What the Supreme Court did today was confirm that the injunction is going to stay in place, and they sent the case back down to the district court to evaluate this for cause and see if Lisa Cook really could be fired for cause, which would be obviously their preferred outcome, because then they could give Trump what he wanted, which is getting rid of Lisa Cook and replacing her with someone more pliable, but still preserving these protections for the Federal Reserve, because gutting those protections freak out the stock market.
Right.
This was a 5-4 decision with Roberts and Kavanaugh switching sides to join the majority.
Yeah, and I think, Liz, you and I read this case exactly the same way, right? This is the bare 5-justice majority on the Supreme Court saying, you can't let him burn down the Federal Reserve, right? Like the opinion concocts this explanation about how the Federal Reserve is actually a continuation of the first bank of the United States, and Alexander Hamilton liked that one, so therefore it doesn't count as an independent agency, and so it's not subject to the Slaughter rule, so please don't have a massive asset set. Like, the effect is that Lisa Cook, and only Lisa Cook, is now protected. She can only be fired for cause, and she's entitled to
and Jerome Powell.
Yeah, and they are entitled to some measure of due process, of which the court does not specify, to contest the firing, which, is good in the individual case, I guess. But, like, it ain't law, right? Like, the majority's description of the Fed is not remotely an accurate retelling of history. We actually have Clarence Thomas to thank for that one in his dissent. But look, the Federal Reserve was created to repudiate the first and second national banks of the U.S., right? Like, to say it's the same thing is just lying about history. And And even if it were, right, Justice Barrett writes, I think, a correct dissent if you proceed from the premise that slaughter was correctly decided, right? She says, how can history support both the categorical rule, that was the rule in slaughter, that the president can fire anybody he wants that's running an agency, and a carve-out? Mm-hmm. and look, she's aided by what Roberts said in slaughter, right? In slaughter, he said, direct quote, "The president must have the assistance of officers he can trust. Neither Congress nor the courts may saddle him with those with whom he cannot work." And then, in the next opinion, Roberts turned around and saddled him with Lisa Cook.
Yeah, it's so completely inconsistent. I mean, she's not wrong that it's inconsistent, and I have occasionally defended Justice Barrett as a person who is still, can be shamed, unlike her male colleagues who more or less never can be shamed, are never ashamed, no matter how ahistorical or illogical or destructive what they've done is. But I do think she's amenable to shame. But here, she also kind of shows her hand, because what she's saying is, I want everything to be consistent, but I want it to be consistent with this rule that we just made up. Right. We should not have exceptions. We should have our rules. I don't care about stare decisis when it's somebody else's precedent. I care about stare decisis when it's my precedent, when it's these rules we're making for the rest of the country going forward. And I'm not going to give her props for honesty or anything. I mean, I know that you posted on social media she's so close to getting it, but I don't love it. Anyway, Lisa Cook's job is safe for the moment, although, Donald Trump posted on Truth Social this morning after the decision came out. The Cook lawsuit, having to do with her suitability in sitting on the board of the Federal Reserve, was sent back by the Supreme Court on a strictly procedural basis. We will take appropriate action immediately to make sure that someone who has committed wrongdoing will not be making vital decisions concerning the welfare of the United States of America. Thank you for your attention to this matter, President Donald J. Trump. And then, amazingly, lightning did not strike him for brutal assault on irony.
He was also directly honest, right? Immediately after that tweet, he said that the slaughter decision overturns 90 years of precedent and is a massive expansion of presidential power. He adds, at a time when it is most needed. But look, you can tell Donald Trump does not play poker. He does not keep his cards close to his vest, and he is pleased with what the Supreme Court delivered up to him today.
Well, he can't stay awake long enough to play poker. Let's be honest here. Who are we fooling? Okay, tomorrow, obviously, there will be those final 4 Supreme Court decisions. And then I assume by Friday, we will know whether Justice Alito is indeed going to be retiring or not retiring. The word on the street is that he's not.
I've been trying to hold out hope for a long time. Plus, I've been sending him psychic vibes that says, "You're the only smart one, Sam. You're the only smart one, Sam. They can't do it without you. They can't do it without you."
Yeah, right. Chief Justice Roberts and Justice Barrett will go soft without you there.
You lost Kavanaugh today. He's a squish. Only you can do it, Sam. Stick it out. Stick it out.
Okay. There is a very important Fourth Amendment decision, which we're going to discuss in the subscriber bonus. It has to do with geofencing and whether you have a right to privacy in your cell phone data, which you do. I mean, that one actually came out pretty good, and we will tell you all about it if you're a subscriber at patreon.com/lawandchaospod or lawandchaospod.com. And if not, we will see you on the other side. That will be Thursday with written content and Friday with another show. Thanks, guys.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.